Good evening, everyone. Welcome to the Elville webinar series. We are so pleased to be with you for some important and high-level education this evening. And this evening is made possible by our longtime friends at the ARC of Frederick County and the ARC Northern Chesapeake region, both Lauren Harper and Corby Fowler. Thank you for organizing this and putting it together. Lauren, you're here on camera. Do you want to say anything briefly?
No, we're really excited to have everyone here, and we hope we can all get a lot of useful information. And if anyone needs any more, you can contact Elville and Associates or reach out to the ARC, and we can help get you.
Absolutely. So our topic tonight is, thank you. Our topic tonight is planning for a loved one with special needs, an overview of guardianship, supported decision-making, and special needs trust. And your presenter is an outstanding educator and counselor, Mr. Stephen Elville, our managing principal and lead attorney here at the firm. And I'm Jeff Stauffer. I'm the Community Relations Director, and I'll be your moderator tonight. We have lots and lots of new attendees here this evening. So a few very general housekeeping items. We always encourage your general questions. So note them in the questions panel anytime, and we'll pause periodically to address them. And your questions always add a lot of value to the presentation. And this morning by email, you should have received the presentation slides Steve is going to go through this evening. If you didn't receive them for some reason and registered very late, they're in the section marked handouts on your screen to download as well. So I'd like to offer Steve and the firm a brief yet proper introduction before we get started, and a question: what makes Elville and Associates different from all the other law firms, all the other attorneys you may have worked with or seen out there on commercials? And hopefully that's going to be very clear to you in the next 75 minutes or so. So you should be able to see my screen here. Our firm was founded in 2010 in Columbia by Steve Elville. We have many different practice areas that we focus on here. I'm not going to go through them all, but estate and special needs planning are certainly a couple of them. We have 9 attorneys and 12 staff members in 3 locations, including our new Rockville location. We're very happy about so far since April. Our mission, it's always been the same for the last 14 years. I've been here for 11, and that's to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And you're going to hear education a lot here during the evening. We focus on that in many different ways, including different planning processes with our clients. And we have programs to suit all families and individuals here at Elville and Associates. We do many educational webinars and workshops in the communities that we serve each year. We also have an accredited client care program here, one of only a couple firms in Maryland to have a client care program accredited through the Client Care Academy in Boston. Here at the firm, we also always work with the ideals of client education, collaboration, and compassion with every client every day here at the firm. And just a bit about Steve. I could talk all night about Steve, but we don't have time for that. His work has been centered in elder law, special needs planning, and estate planning with an emphasis in tax planning and asset protection. Lots of work in the special needs arena. We've been very blessed over the years. Member of many different national membership and professional organizations, as you'll see there. Steve works to bring peace of mind to clients by creating solutions to the needs through counseling, client education, and the use of leading edge legal technical knowledge. Steve has presented thousands of times over the years. I've been fortunate to be with him through many of them. Also named to the Maryland Super Lawyers list for a 9th time and 8th consecutive year in 2024. And also, Steve had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization Steve founded in 2014. I'm very fortunate to be the director of. So when we have more time, if you'd like to reach out and learn how we work to make a musical difference in the lives of children each day, I would be very happy to share our story with you. For now, we have a lot to cover. Steve, I'm going to go ahead and turn it over to you, and I'm going to make you the presenter. So look for that button. Okay, should see that pop up.
See it now, Jeff, and I'm getting my screen up and starting my slideshow. Thank you very much, Jeff, for that nice introduction. And good evening, everyone. And I know many people are still getting on the presentation, and we're just going to Jeff, I apologize. My screen changed on me there, and there we go.
We can see it now. You're good to go.
All right. Thank you very much. Very good. And again, welcome everyone. I know several people are probably still getting on the webinar tonight. My name is Steve Elville. I'm the lead attorney of Elville and Associates. I want to thank the ARC of Frederick and the ARC of the Northern Chesapeake for the privilege of presenting tonight. And it is my great privilege to be here tonight to educate, provide information and support, because we've been very privileged for many years to be an integral part of the estate planning community for special needs in Maryland. And I don't want to start without wishing every one of you a happy holiday season ahead. And also I want to say that in addition to it being a privilege, that there are many, many things we're going to cover tonight. Some of this is overwhelming amount of information, but the thing I want you to remember is that we are here to be a resource to you. You're going to be offered a chance to have a no-cost consultation with us about your particular situation, whatever it may be in this subject matter, and also that all estate plans and all special needs plans should be reviewed. So those are really the 3 or 4 bullet points that I want you to remember tonight, no matter how much information that we're going to cover. So we're here to be a resource. Again, thank you. And we normally spend a little bit more time in introduction, but because we have so much information to cover tonight, we're going to get right into the presentation. All right, I'll get my slideshow working here. This educational program is exactly that. It is not meant to be legal advice. If we do meet virtually or in person or by telephone, there is an attorney-client privilege. There is nothing to be concerned about, but here we're just talking about very high-level education. So this is not an attorney-client relationship here in this presentation. We're going to talk about many things. We're going to talk about guardianship and its drawbacks and benefits. We're going to talk about what are some alternatives to guardianship. We're going to talk about supported decision-making. We're going to talk about the different types of special needs trusts as we just go down this list, and other tools and resources that families should really be aware of. So if you have a pad of paper or a smartphone or a tablet, whatever you have, I would suggest that you get comfortable and get ready to make some notes, because probably you're going to pick up something throughout this presentation, several bullet points, things that you may not have known, things that you're going to want to note. So we'll keep moving. We will take some questions if we have any time at the end. We are told we have until 7:30, so we're going to try to make the most of it. But we also are going to give you a chance again to have your plan reviewed, or to just meet with us and make sure that we can talk about your particular situation. So what is planning? Well, planning for a loved one with special needs is about enhancing that person's quality of life to the maximum extent possible. And of course, many of you do that, all of you do that with your loved ones. And note the last part here, protecting them as much as necessary, but not limiting or restricting their potential. So this is a fine line, but from the attorney's point of view, we are working towards enhancing this type of planning, customized to whatever that situation may be. And there's lots of benefits of planning, and many of you already know this. I know you're very busy in your lives. I'm going to be talking to you about a lot of things that many of you already know, but your busy lives don't necessarily allow you to focus on it. Providing financial security, understanding and leveraging public benefits, or what we call means-tested benefits. We want to have a management team, a proper team. Appropriate housing. Many of you have this concern first and foremost on your mind. How is my loved one going to have proper housing? An ongoing system of advocacy. We had several clients in the office today. We were talking about advocacy in the future. Coordinating the entire family's efforts, protecting beneficiaries from bad things, predators, fraud and abuse. And then for some of you, it's important as part of the planning to preserve assets for others after, God forbid, your loved one with disabilities may pass. So successful planning has to do with having a team of advisors. Many of you do not have the appropriate team. You do not have the right attorney, or you don't have the right financial advisor. You don't have a CPA. You don't have an aging life care manager or an advocate, or maybe you need an insurance professional. So we're here to help you figure out whether you should have a team and help you have a team. Some of you do have a team. If you do have a team already, We advise that you talk to your team and make sure that they're talking among themselves. We want to make sure that they are actually talking to each other in your best interest. Note this big second bullet point, flexibility. One of the biggest issues is flexibility. We had our annual client event on Saturday. Professor Jason Frank was there, who used to be a prolific Maryland elder law attorney. We were all in agreement that flexibility is one of the things we have to make sure we are building in today's world. So we talked about an advisory team or this collaborative team. Sometimes in this presentation, I'm going to be redundant so that I drive home that information to you and you can get a second and third chance to absorb it. Again, making sure we have flexibility. Look at this last bullet point. Does your plan have a trust protector? A trust protector is a special fiduciary that you need to learn more about. So let's talk about creating an effective plan. We want to have time to think about this stuff. Most of you don't have this time. Where will your loved one live in the future? What level of care is required? Will there be a guardianship or conservatorship necessary or something lesser involved? Who are all the players? What kind of lifestyle is necessary? I was talking to a client earlier this morning. We're talking about a life care plan. How much money will be needed over the years to come? What are the future challenges? I would encourage you to build layers into the planning, but understanding your purpose, understanding your process. All planning is goal-driven, including special needs planning. Now, one of the things you can do in special needs planning today, and we're going to talk about the special needs trusts at the latter part of the presentation. Normally, we talk about it at the beginning. We can create a memorandum. We can create a letter of intent or a memorandum that describes your loved one's needs, their particular eccentricities and wishes and the things they like and dislike. Who are available? Are there other family members? Who are the trustees? Who are the caregivers? Who are the doctors? Who are the people involved in the person's life? You can create this memorandum and it can be part of the special needs trust, or you can create a binder. You can create a binder of information. And we've had some very generous people as clients who have created binders, and they've given us the right to basically show other clients the tabs that they used in their binder. So just understand that this creation of a memorandum of intent or a binder is the thing that can make the special needs plan unique to your particular loved one. So we need to think about estimating income and expenses. For those of you who do not have a financial advisor, remember that they have tools they can use to help you project, is what I'm trying to say, the expenses and the needs for the future. We want to use those resources, and in some cases, we want to develop a life care plan. Now, if your loved one is of higher functioning capability, or meaning they have mental capacity, we may want them to sign documents as well as part of the highest and best kind of special needs plan. So we're going to talk about this in the guardianship portion a little bit, but just know if part of good special needs planning may include having the loved one with disabilities execute their own financial powers of attorney and advance directive. So making sure that we stay on time throughout the presentation, I'm going to get right into the guardianship and conservatorship portion. Many of you have loved ones under guardianship. We're going to talk about this. Guardianship is the most invasive form of intervention. For those of you whose loved ones are turning 18, this is going to be a consideration for you. This basically presumes your loved ones lack the capacity to basically make their own decisions. Guardianship, there's two different types. The guardianship of the person, that's the most common type. The guardian gets to decide where the person lives, gets to make their medical decisions. Many of you are the guardians of the person of your loved one. Then there's the guardianship of the property, or some places call this the guardianship of the estate. So as I mentioned, the guardianship idea is the highest form of intervention. What we're going to do here in just a few minutes is we're going to juxtapose the idea of guardianship with lesser restrictive alternatives. And so many of you on this webinar do not have a child under guardianship, and you've made the decision not to go this direction. So what is guardianship? Is a loss of legal rights It is cumbersome, it is expensive, it is a loss of flexibility, and it is subject to court oversight and annual reporting. Is guardianship necessary? Absolutely necessary in many cases, but we're going to talk about the pros and cons of it here tonight. So before you make a decision to pursue guardianship, you're going to want to carefully evaluate this idea of the mental capacity of your loved one. Some people are going to be on the fence about this, and rightly so. We sit with clients every month who are torn about this issue. The question is one of the questions I should say, is your loved one vulnerable? Do they need protection? Have you explored, however, other options? We're going to talk about that. And would your situation be best settled by way of some kind of an agreement instead of a full-fledged guardianship? Now, again, guardianship is the most restrictive alternative. It's a process that I would say routinely takes 45 to 60 days. There are some pitfalls in the process. As long as you're educated about this and have both eyes open, you will get through the guardianship process. But if it is contested, which it usually is not in the case of most special needs families, but if it is, it can be very emotional, very costly, and it can be very, very difficult. So we want to carefully be thinking about this process and juxtapose that with lesser restrictive alternatives. So speaking of that, what are some of the lesser restrictive alternatives to guardianship? And many of you probably are very educated about this. I have presented at the ARC of Frederick, for example, twice. And one time years ago, I presented with Megan Rusiano, who was the Maryland basic driving force of supported decision making. So many of you have heard these things, but let's talk about it again. So financial powers of attorney and advanced medical directives are alternatives to guardianship because those things provide for agents. And when your loved one has an agent, they are avoiding guardianship as long as those agents get along. Joint ownership of assets avoids guardianship. Representative payee under SSI or SSDI of Social Security benefits avoids guardianship. Consent agreements, meaning court agreements that are short of guardianship, avoid guardianship. And supported decision-making avoids guardianship. So let's take some further looks at this. So many of you are familiar now, after a couple of years, you're familiar with supported decision-making, and I'm going to give you my take on it. I remember the first time I presented at the ARC of Frederick about this. I know that it's a bit mystifying to some parents. For some parents, it's going to make a lot of sense and relatives. For other people, it will not. So let's get into this and you can make your own decisions and we can talk about it later or further. So supported decision-making is a tool. In my opinion, it's a tool where a person with disabilities can be empowered and supported in the process of making their own decisions to whatever extent possible that they can make those decisions. It's a simple written agreement, but for some of you, this will make no sense. It does not have to be an agreement. It can be verbal. So the Maryland law went from zero, not having any supported decision-making law, even though DC and Delaware had supported decision-making. We've gone to an extremely, very broad law. It is a formalized authority that the supporter can be recognized and the person who's making the decisions with the help of a supporter be recognized as such. It is an alternative to guardianship. It's a potential addition to powers of attorney and advanced directives. Right now, if you're getting confused, I promise I will eventually show you a chart that hopefully will clear this up. I created the chart and you'll be able to see it. It's a potential tool in guardianship, although I am not seeing this happen really. It's supposed to be allowed in Maryland in guardianship. So a person could be under guardianship and still have a supporter. It is a paradigm shift. It's a shift away from the idea of protection to an idea of risk. So this is a whole new world of self-determination for people who are young or old. And as I mentioned, this is going to make sense to some of you, and for some of you, this will not make sense. So players like Megan Rusiano and others and the ARC advocated for this, and it was successful. And so thank goodness Maryland does have this now. and we have alternatives to guardianship. Brief history, as many of you may know, this emanated in British Columbia. It comes down from a United Nations mandate. There were several states ahead of Maryland. Maryland finally passed this. And it is designed to give other choices, other support, other self-determination to people with disabilities around the world. So along these lines, there was no real good alternative to guardianship in Maryland. There was either this notion of capacity, a person has the ability to sign documents, or they don't, and they have to be under guardianship. And the only way to be in the middle was to file a guardianship and then have to settle it by way of something called a consent agreement. So all of this is a bunch of legal explanation, but the bottom line is old notions of traditional guardianship are now being uprooted. And the culture of what I might call protection or paternalism has now loosened up. And some of you may agree with this or disagree with this to various degrees. And I understand that. But people with disabilities are, at least theoretically, allowed to make more decisions with more risk because they can be more self-determining. So if we're talking about this self-determination, a power of attorney would basically say what? If I was signing this advance directive or a financial power of attorney, I am in charge of my own rights. I will make my own decision. And if I can't, my agent will step into my shoes and make my decisions. So with the power of attorney, as you're going to see on my chart, there is no loss of rights. If you go to the bottom of the page here, it says if I'm under guardianship, by definition, I cannot make my own decisions and I need the protection of a guardian. So that's kind of the opposite. That's a loss of rights. But if we look in the middle here, it says, but if I have a supported decision-making agreement or I have a supporter, I don't give up my rights. I can make my own decisions to whatever extent I can, depending on my limitations or disabilities, provided that I have the support to do so. So power of attorney, advance directive, no loss of rights. Supported decision-making, no loss of rights. Guardianship, loss of rights. So here's my chart. And I just developed this to try to give clients a visual overview of this. If you look at the left, power of attorney, advance directive, your loved one is retaining their rights. No loss of rights. I can make my own decisions. In the middle, I can make my own decisions also. So as long as I have support, over to the right, guardianship and loss of rights. Now you'll see that supported decision making is possible under guardianship, but I personally have seen 2 or 3 cases where judges have denied this. So right now I have to say Maryland is not really being very flexible with that. So that will be disappointing for many of you, but I want you to look at this chart and you'll have this in your materials. So supported decision making is not a power of attorney. It is not a way for another person to make decisions for your loved one. It is not giving authority to a third person to do whatever they want. It is not a mechanism where the person gives up their rights. It is not guardianship. So it is not any of those things. It is a theory that the person who needs support can make their own decisions provided they have enough support to do so. What is the difference between supported decision making and guardianship? Guardianship is, as I mentioned, the removal of the person's rights, the removal of the person's right to determine where they live, their health care, even voting. They don't have any legal choice, really. It is a protectionist kind of thing, and rightly so. In many cases, the person under guardianship absolutely needs protection. And there is a kind of an unspoken consensus that it's permanent. Supported decision-making is no removal of rights. There is a potential actually for restoration of rights. A person under guardianship could be deemed by 2 position statements to not need guardianship and therefore be able to live under the auspices of a supported decision-making agreement. So this is just a new world of thinking. The right of the individual, the rights remain vested in the individual. And again, this is a paradigm of risk. The more we move back this way on the chart, the more risk, and this is where many of you may disagree or even feel nervous about this, and rightly so. giving your loved one the right to fail, the right to take risks. So these are the differences, and it can be an addition to a financial power of attorney. It can be an addition to an advanced medical directive. All right, so Jeff, I'm going to slow down here just a minute because I was in so big of a concern there that I was going to, not be on time, that I actually got a little bit ahead of myself there. So I'm going to slow down here for just a second to see if anybody has any questions, give people some time to breathe, and if there are no questions, I may pose a couple of questions of my own.
Well, thanks, Steve. We do have one question, and I'm going to go ahead and frame it a certain way here. We have somebody that gets into a very specific discussion about their personal situation, which I think is not necessarily needed right now. But primary question is, with the new administration coming in, do you have any general thoughts as to how that may affect people that have developmental disabilities and their families?
Well, thank you for that wonderful question. Since we are about 15 minutes ahead of time, I'm going to take just a few minutes, and I hope that's okay with our attendees to answer this question. It won't take 15 minutes, but I'm going to just expound. So the way I tried to answer this question, and I'm just assuming that many of you, and sir or madam, I am assuming that you're voicing this question because it's a real concern, and it rightly so should be. So here's how I would look at it, and I don't want to be, kind of a naive person about this. I do want to address this question head on, but I also don't want you to worry unnecessarily. So I'll try to give you my honest opinion about this. So I don't have any direct evidence that people with disabilities are going to be affected by the new administration, but let's look at the historic nature of what's happened. So when there was a Republican majority in 2017, I don't have the exact dates, but you'll understand what I'm saying. The Republican majority sought to overturn the Affordable Care Act. Now, when they did not succeed at that, it was attempted again another year or two later, and it didn't succeed either. But here's where I'm going with that. That was a very serious attempt to shake up the apple cart of how Medicaid services are delivered in the United States. And it really had a lot of people shook up, and many of you may remember this or have been a part of it. And I remember going down to Annapolis and being a part of the Elder Law Section Council of the Bar and seeing people wringing their hands, the National Academy of Elder Law Attorneys, their lobbyists, and other people wringing hands about this. And there was a real fear that the changes in the delivery of the Medicaid program, which were being very seriously threatened or threatened to be changed, were going to cause big issues. So that could have happened, and it didn't. So I want you to remember that there are things that get talked about. They can cause you a lot of anxiety, and I know that many of you do have a lot of anxiety about this. Now, I'm going to juxtapose that a little bit with what happened recently with supported decision-making. Now, remember, supported decision-making is a positive thing, depending on your point of view of this, for persons with disabilities. Now, interestingly, and I'm just trying to belay any kind of excessive worry that you may have. Remember that when I came onto the scene and met Megan Rusiano years ago and began to learn about supported decision-making was where? Alaska, Wisconsin, Indiana, and Texas. Now, I want you to think about that. And I'm not trying, again, to be pie in the sky. I am not trying to act as if nothing's going to happen, but I'm just trying to put this in perspective. Those states had supported decision-making before Maryland and years before Maryland. And all of those, as far as I can tell, Jeff, all of those states, I believe, are red states. And I want to say that Texas even has supported decision-making. So what's really strange is that I think many of us do think that, not to try to be purely political in my answer, but I think many of us believe that people that live in blue states, so to speak, we are going to have the benefit of, excellent public benefits for people with special needs, where people who maybe live in red states or the red wave, let's say, is going to do something to alter the rights of people with disabilities or their benefits. So I'm just juxtaposing that because I'm trying to give an honest answer. So yes, we were very worried in 2016, 2017, 2018. Nothing happened. Then I want to point out that with at least supported decision making, several states that we might consider red states, I guess, were the leaders in supported decision making. It doesn't seem to make any sense to a lot of people. So now, with all that said, am I worried? Well, I'm worried that the Affordable Care Act or the delivery of Medicaid services could be thrown into an upheaval again. I'm absolutely believe that that's possible, and I want to be honest about that. However, I think the thing that you should understand is whether it's about estate taxes or whether it's about trusts and estates or income taxes, a lot of ideas get thrown about. A lot of ideas get thrown about from people on the left, like Senator Sanders, or the possible Harris administration that was going to come in, and they were going to lower the estate tax exemption down to $3.5 million instead of 13.6 million. And income tax rates are going to go up to 39.6 if they had won. And all of these things that get tossed about, including the taxation of unrealized capital gains. All these things get tossed about, and yet over the years, I've seen many things tossed about and nothing ever happened. So I'm going to get to the bottom of the final answer here for you the best way I can. I want you to be aware of it. I want you to know that it's possibly going to happen, that the apple cart could be shaken up. There's no question about that. The delivery of Medicaid services could be shaken up. We hope not. But I want you to juxtapose that with the things that get thrown about that never happen, just like what happened in 2017, 2018, plus what happens in the world of estates and trust, that all of these proposals come out and many of them don't happen. So I want you to kind of keep that in mind. I want you to keep in mind that some of the, quote, red states were the leaders in supported decision making. And now what do we do about it? Well, the thing to do about it is to do exactly what you're doing tonight. You're educating yourself, you're listening to another opinion, you are asking questions. But here's the bigger part. What I would throw out is the way to deal with this is to build flexibility into your planning. There are ways to take either your existing older special needs trust or your basic estate plan, or arguably the financial powers of attorney, which are, it's not going to make a lot of sense to you, but this is arguably the most important of all the documents, not only for you, but for your loved ones with disabilities. Make sure all those documents are as flexible as they possibly can be, to make sure that they are as updated as they possibly can be, and to be aware of the new laws that exist, such as, don't have time to get into this, but decanting, which gives you peace of mind that your special needs plan could be altered in the future if the laws change or a new trust had to be created after your death. The use of what is called non-judicial settlement agreements, which provide flexibility. The use of trust protectors. So I know this is a long answer and I apologize, but I thought that I should take 5 minutes here and really give you a full-fledged response, because I know that many of you are going to be very, very worried about this. And I'm just trying to put it in perspective. And I'm arguing that even if changes in the laws occur, you are still alive, and therefore you can make changes in your special needs trust, your estate planning, to deal with whatever circumstance may arise. And if you are not well enough to make those changes, you can build enough flexibility into your planning, and you can have educated family members and fiduciaries, trustees, trust protectors. You can have these advocates well versed enough and enough flexibility in your planning that your plan can be altered if it had to be altered if the laws change. So I don't have any direct evidence that this is going to happen, but I do think we need to be prepared and we need to build flexibility into our planning. Jeff, do we have any more questions?
Yeah, Steve, thank you. Our good client, Mr. Balin here, asked if Maryland has a form to fill out for supported decision making.
Thank you, Mr. Balin. The answer is no. Maryland chose to not provide a form. Maryland, states like Indiana do provide their own form. I think DC does as well. Maryland says that individuals should be able to make their own form, or lawyers should make a form. So, Mr. Balin, we do have a form that we've developed, and of course it can be altered a little bit, but the only thing the statute says is create a form that complies with the law, and that'll have to be sufficient. So we'll be happy to get you a form that can be used.
Okay, thanks. Time for one more.
Yes, go ahead, Jeff.
Okay, and just a very general question. What is the first step I need to take? A person recently attained guardianship for her adult nonverbal son, and I need next steps in putting things in place.
Oh, thank you for that wonderful question. So the next step would be just set an appointment, and Jeff can talk to my assistant Barbara. We will make an appointment, and we will send you a questionnaire because we want to learn more about you, and we want to sit with you and just look at the situation. That would be your next step for sure. And then we can proceed to do planning based on whatever your situation is. And if you do have existing documents in place already, we want to see those existing documents. So that's your next step. Thank you for that.
Okay, Steve, thank you.
Thank you, Jeff. Okay, so I know I kind of got through all that information. I wanted to make sure that we had at least half our time to cover special needs trust. So if you need to backtrack, if you have questions, we're going to probably still have time at the end. Thank you for your wonderful questions. So let's get into the part that many of you have come tonight for, which is to look at special needs trust. So I want you to understand that there are three major types of trusts in special needs, and really two categories. There's the third-party trust, and that's the kind that most of you are going to be concerned about tonight. You are a third party, and you are leaving money to a trust for the benefit of your loved one. So the way I'd like you to think about this is you are point A. You are the third party that's leaving the money. Your trust for your loved one is point B. You're point A, the trust is point B. Your loved one is point C. And so you'll notice that when you pass away, you're leaving money straight to point B, which is the trust. You're not leaving the money to your loved one. So that's called a third-party supplemental needs trust. That's a mouthful. A third-party supplemental needs trust. And that is what I would call the most common trust in special needs planning. And you'll notice this chart goes left to right. It says anyone can create this trust except for the beneficiary, and anyone can leave funds to it except the beneficiary. And here's something that's a bit sobering, but it's a good news, that God forbid your loved one were to pass away, your wishes, the wishes of the grantor control, and the money gets to be left wherever you say it goes. So the third-party trust is the most common trust. We're going to see some slides about this. There is no payback to the state of Maryland or any other state. The laws of all states say if you are a third party and you leave money to what is called a discretionary trust, it's a special needs trust, then at the beneficiary's death, it goes wherever you say, and there is no payback. This is the most common form of the type of planning that you need. Now, you'll notice these fancy letters here in the middle column, the D4A trust and the D4C trust. These are first-party trusts. So this is where your loved one has received money from an inheritance, or maybe they had a birth injury, or maybe they, God forbid, were injured in a car accident or had a brain injury. They have received money, and some of you on this webinar probably have loved ones that have these first-party trusts. These are trusts that are approved by the state of Maryland, and now at the death of your loved one, these trusts have to be paid back. Pooled trusts are like Maryland First Disability Trust or the Arc of Northern Virginia or First Horizons. The trust we most commonly deal with is the D4A trust, where someone has received an inheritance they shouldn't have received. Now they're knocked off their public benefits. But this trust has to be established before age 65, and a parent, grandparent, guardian, court, or notice this, the disabled person themselves, if they're a higher functioning person with capacity, they can create their own D4A trust, but it may have to be paid back to the state if that person dies with money there. Now, sometimes we don't have a choice. We do have to use the first party trust. If there's a military veteran that's leaving his or her pension to the loved one, then we have to leave that pension to a first party trust. If a person is receiving some kind of settlement, we have to leave it in a first party trust. So the third party trust is the thing you're going to be most concerned about tonight. If your loved one has money in their own name that they shouldn't have, then we're going to use a first party trust. So the third party trust, again, is the best method for leaving assets to your loved one when you pass away. And it's called a third party trust because it's the assets of someone else. It's your assets or the assets of another relative that are coming into that trust for the benefit of your loved one with disabilities. So the beneficiary didn't create the trust, you did. The trust does not hold any of the beneficiary's money, and the beneficiary is not the trustee. Okay, so these are the basic things to take away from tonight. There's no payback requirements. You can leave the assets to wherever you want or whoever you want, even to charity. And this is something that that Uncle Sam wasn't allowing about 2 years ago, but now the Uncle Sam is saying, yes, you can leave assets to charity in a special needs trust, and I should be more specific, IRAs to charities, because that was a big issue, which we can talk about at another time. A third-party trust could be irrevocable or revocable, and there's flexibility that can be built in. And this goes to my long answer there about 10 minutes ago about flexibility. Now, this is what a contemporary special needs trust looks like. I want to point out that Maryland has a law, and it's called the Maryland Discretionary Trust Act. So the Maryland Discretionary Trust Act says we can create a trust for someone, a loved one, and as long as it meets the requirements of Maryland law, that trust is exempt. Your loved one is over here receiving means-tested benefits, but you have died, or even during your lifetime, you funded this trust for the benefit of your loved one. That trust does not mess up their public benefits. It is not an available resource for public benefits. Now, we don't have time to describe every single feature, but here is an example of a special needs trust that has a lot of layers on it. It has a lot of flexibility. The truth is, if we just had a plain vanilla special needs trust established under Maryland law, under the Maryland Discretionary Trust Act, we wouldn't have to have any of these layers. But the truth is that if we didn't also add these layers, we wouldn't have the flexibility that we'd really like to have. So we're kind of in a world where I recommend adding these layers. So what are we talking about? Trustee, right there in the middle. Nothing could be more important than who's your trustee. And as part of our planning process, we're going to take a lot of time talking about who should be the trustees of the trust. The trust protector, and you can learn more about this later, the trust protector is not required, but I'd highly recommend that if you develop a special needs trust or supplemental needs trust, you have flexibility. And this is going to the question, the wonderful question of about 10 or 15 minutes ago, about having flexibility. A trust protector can amend a trust or change trustees if the trustees are not doing their job, or the trustees are ill or refuse to serve. We want to have Maryland able provisions possibly. We want to provide that an advocate would be hired after your death. We want to have the memorandum of intent, or that binder I was talking about. We might have a provision for a trust advisory committee. And we also might have a provision for retirement plan assets, which we're going to get to before we end tonight. And that is a brief discussion of the Secure Act, S-E-C-U-R-E, the Secure Act, which affects how you leave retirement plan assets to a child or a trust. So what can a supplemental needs trust pay for? Well, it can pay for basically anything for the benefit of the loved one with disabilities. Now, a traditional supplemental needs trust is going to say, maximize public benefits, and use this trust for the benefit of my loved one as a supplement. So what I would like you to think about as far as a supplemental need trust is your loved one is living their lives, you support them. They also have the support of means tested benefits. That's another world that they have. And then this supplemental needs trust is another world that you're creating for them to supplement this. Now, some of you may create supplemental needs trusts that are more liberal than that, but the traditional notion is maximize public benefits and then use this for supplemental needs. But we can be a little bit more aggressive and a little bit more liberal if we want to. So you're going to be asking yourself as a trustee, what will my successor trustees do? Well, they're going to distribute funds either to your loved one or for the benefit of your loved one. And when you think about that, that's what the job of a trustee is to distribute either to or for the benefit of the beneficiary. Now, if we have a beneficiary on means tested benefits, 9 times out of 10 or 98 times out of 100, we don't want the trustee to distribute to the beneficiary. We want them to distribute for the benefit of the beneficiary. So my simple example is always this. Your loved one needed a new iPad or needed a new computer. So now the trustee is either going to give that person $1,000 or they're just going to buy the computer. So 9 times out of 10, the trustee is just going to buy the computer, which is a distribution for the benefit of your loved one. And that, if the trustee does that, they will never run afoul of the rules. They will never disqualify your loved one from, from their public benefits. Now, some of you are going to want to know more about special needs trusts after tonight. So I'm going to recommend a book. I didn't write the book, but Kevin Urbash of the National Academy of Special Needs Planners. It's Kevin Urbash, U-R-B-A-T-S-C-H. He has written a great book. It's called How to Administer the California Special Needs Trust. How to Administer the California Special Needs Trust. It's just a great book. It is about California, but I don't want you to worry about that. It's not California, Maryland, California. And it is a great book to be able to learn some of these concepts. Why would you be thinking about this? Well, not only do you want to understand all these concepts, but we need to make sure that your trustee understands. We want a trustee who's educated, a trustee who reads the trust, a trustee who would be willing to read that book, for example. Now, do they have to read the book? And the answer is no, but we want to make sure that they understand fundamental concepts. Now, some of you are going to ask, how much should I fund in my special needs trust? Well, you're possibly going to treat all your children equally, or you may decide to treat them unequally. But what we want to do is look at life insurance as a tool. Most of us do not know how much money we're going to have when we die. So in a perfect world, a family with a loved one with special needs would buy permanent life insurance. It's not cheap, but buy permanent life insurance to fund this trust, but you may or may not do that. We want to optimize for retirement plan benefits. We want to work with CPAs and financial advisors. So we just want to collaborate and really work toward the highest and best, and then educate our fiduciaries. Jeff, are there any questions? I'm just going to stop for just a minute.
Thanks, Steve. We do have a really good question here.
Great.
And it is, I would like to do supported decision-making for my teen at 18, but unless I'm misunderstanding something, which is possible, there's not much protection that comes from SDM. My teen is about a level 2. I'm not confident that he could make, for example, the best medical decisions for himself. He could also be taken advantage of by a person with bad intent, and having a guardianship that we run like SDM or SDM under guardianship sounds like a good compromise or solution, but you're saying Maryland tends to throw those cases out, correct?
Yes, and thank you for that. And you're picking up on everything I was saying just perfectly, so I'm glad you did. I think that, you're going to ask yourself a fundamental question when your teen turns 18, and that is, are you going to pursue guardianship? And you may end up pursuing guardianship for this very reason, vulnerability and so forth. Or maybe you're going to hold off for a while and say, you know, I'm not going to pursue this. I'm going to take a wait and see approach for the next 3 or 4 years. But there's no question that the supported decision-making idea as a substitute for guardianship, it does leave the loved one with disabilities, your teen, in a situation where they are deemed to be able to make their own decisions. Now, they may not be able to make all decisions, but maybe they make a certain level of decisions. They can express their preferences. So we might look at supported decision-making as an accommodation. And then you may decide as a parent, there's just not enough protections here for me to be comfortable with this. And I think that's going to be dispositive of guardianship. Meaning, you know, I was really trying to be open-minded, but there's just not enough protection here. I'm not willing to go forward without any kind of protections. I can buy into this idea of risk to a certain degree, but I just can't go any further with it. So I understand what you're saying, and it's got to be a tough position to be in. I'll try to describe what I've seen so far. There might be other lawyers who have seen something different. I was involved in a case in a Maryland county about a year and a half ago or a year ago, where I was an expert witness, and I watched a very top judge very carefully listen to a 3-day trial about many issues, but it was about someone under guardianship and whether they should be allowed. One of the issues was whether they should be allowed to have a supporter, and it's very clear in the statute, very, very clear, that a person under guardianship is allowed to have a supporter, meaning they are under guardianship. If you ask me, this is what it means. Now, other lawyers may disagree with me. The person under guardianship has lost their legal rights. There's no question. But however, because they have a right to have a supporter, they really haven't lost all of their rights, meaning no person under guardianship ever loses all their rights. But what I'm saying is, for all practical purposes, they've lost their rights. But now they have enhanced rights with this person who they can express their preferences to. What I'm seeing in that case and another case was the judge basically said that even though the statute is very clear, they're just not going to allow it, because they don't seem to be able to understand how a person can lose their rights and still have the right to make some of their own decisions under guardianship. So it just seems to be something that doesn't legally make any sense to them, but the statute is very clear. So I think that they're wrong on that, or they're being very selective about who's under guardianship and is allowed to have a supporter. So I think if you end up petitioning for guardianship, I think all you can do is really say, okay, I've got the statute here. It clearly says that unless the guardian objects, unless the guardian says, no, I'm not going to allow this person to have a supporter, that the person has the right to have a supporter, even under guardianship. So I think all you can do is say, okay, this thing is still in its early development, and if I petition for guardianship, I may ask for a supporter even under guardianship.
Okay, thank you, Steve. And one more. When should the guardianship process begin? I have a son turning 18 in May.
That's a wonderful question. Thank you. I would say it probably, depending on your county, it probably would not be able to start until the time that he or she actually turns 18. Now, in the old days, just a few years ago, we were able to start the process of guardianship about 60 days in advance. We were able to meet with the parents, get a petition going, get it submitted to the court, and then there was this understanding that as long as the hearing did not happen until the child had turned 18, then everything was fine and the parents could get a jump on the guardianship process. But up where we are right now in Howard County and other surrounding counties, they don't seem to be allowing that now. So wherever you live, we're either going to have to meet 60 days ahead of time and get ready to petition when your child turns 18, or maybe in your county it will be allowed that we could actually submit the petition before the child turns 18. But that's a good rule of thumb, is I would say start about 60 days ahead of time.
Okay, one more, if that's okay. Really
Sure.
good question. If this person has the question, I'm sure many others do. So what happens with a third-party special needs trust after the grantor or parent dies and sometime later the beneficiary, in this case son, dies and there is still money left? Would remaining money be able to go to the siblings of the deceased beneficiary?
Thank you for that wonderful question. And the answer is yes. So depending on how the parents drafted this trust, when they died, there are successor trustees that stepped in and kept the trust going for the person with disabilities. Then when the person died with disabilities, they were the primary beneficiary, and now the funds would go to another series of beneficiaries, which in your case, it sounds like would be siblings and so forth. So that's exactly what would happen, and there would be no payback to Maryland.
Okay, Steve, thank you.
Thank you, Jeff, and thank you for all those wonderful questions. It's made our presentation so much better and so much more interesting, I'm sure. So now as we continue on, we've got plenty of time here. It's just 3 minutes before 7. We're going to go to up to 7:30, but we may end early. So some of you are asking all the right questions, and I'm sure there's no one on this webinar that would do this, but just remember the reason that we don't want to leave an outright inheritance is someone who receives the money would lose their benefits at least temporarily, and then we would have to put the money in a payback trust. So this is why outright inheritance to someone with disabilities obviously is a very bad idea. One of the things I've seen oftentimes is situations where we see trusts that are just plain wrong. They're just not special need trusts. Someone, I hate to say this because this is kind of scary to you as potential clients of any law firm, is that there are people out there that are maybe good people that are lawyers, but they sometimes don't understand the world of special needs planning, and it's very easy to get mixed up. So sometimes they implement trusts that are the wrong trusts. So it could be a trust that is not a discretionary trust. It could be a trust that is what we call a support trust. You inadvertently created the wrong trust, and I have seen this not every day, not every month, but I do see it at least 2 or 3 times a year where someone has the wrong kind of trust. So we want to avoid outright inheritance. We want to avoid leaving assets to the wrong kind of trust. Obviously, we want to leave it to the correct kind of supplemental needs trust. Disinheritance is a big problem. We don't want to do that because the money would go to another sibling or loved one. But what if that loved one were to pass away? You thought you did the right thing. You left it to them. They had all the best intentions of the world to take care of your loved one, but then they passed away and their assets went to someone else. Or you left assets to them and they, unbeknownst to you, they had creditors. And so the assets were subject to the claims of their creditors and they were lost. Or perhaps they were going to get divorced, or many times someone who could be left money could decide not to take care of your loved one. Or another one that's not even on here that I've actually seen happen, someone was left money but lost it to Uncle Sam because they had a tax lien. So we just want to make sure that we use the standard kind of planning procedures with supplemental needs trust to make sure that these kind of arrangements don't ever happen. We talked about the first party trust. This is the planning tool that you're going to just keep in the back of your mind, and you're going to say, you're not going to be shocked or upset if your loved one receives assets they shouldn't receive. Now, if you do planning correctly with a third party trust, what we want other family members to know is that you've done that. And if they plan to leave assets to your loved one, that they leave it to the right trust. But if someone were to, well-meaning person, leave $200,000, $300,000, $400,000 to your loved one, they left them an IRA, they left them an outright distribution, well, just remember, those issues can be handled, and try not to panic because we will get your loved one back on benefits. That is a first party trust, and we talked about that a little bit. The D4A trust, in my opinion, is the most common one. So the common trust, the D4A trust, is used in a personal injury award or a birth injury. Someone inherited assets. A good example of this is a case I had many years ago where someone, a well-meaning uncle left a child, 15 years old, on the autism waiver, left them $500,000 in an IRA. So that kind of thing can be handled. It's unfortunate because that trust will have a payback to the state of Maryland. But on the other hand, remember, because that child was so young in that example, that there's probably not going to be any assets left by the time that child passes away. So remember that these special needs trusts, these first party trusts, they can be created now. If you wanted to create one and just have it sitting there so it's ready, just in case your child were to receive money they shouldn't receive, it can be ready now if you want that, but we can always create one at that time. So now let's get into other planning tools, and you've been a great audience, and I just want to thank everybody. Let's talk about public benefits at a glance. We're not going to get way involved in this, but remember that the thing we want our trustees to understand are these three categories. And I'm going to focus on the first two from the left. So many of you have loved ones that are going to be on SSI, or they are on SSI, and by virtue of being on SSI, they receive medical assistance. So many of you are aware of this. This is the quintessential qualification as a disabled person, and all other benefits seem to emanate from this qualification of SSI. So that is means tested, we know that. Now, in the middle, we have people that are on Social Security disability. Many of you have loved ones that are disabled adult children. They were disabled prior to age 22, and when you retired or someone in the family that was a parent died, the child went from SSI to SSDI. Many of you know this. And so that person now becomes a disabled adult child. They get 50%. If this gets confusing, you're not alone. 50% of the amount of the assets that the parent receives of SSDI, not SSI. And at the parent's death, eventually, the child gets 75%. So this is a very important thing for you to understand, the difference between SSI and SSDI. The disabled adult child has no work record of their own. So they have a work record based on the parent's work record. As a result, they receive SSDI and Medicare, and oftentimes they receive Medicaid. So they're still in the waiver program, or they're still receiving means-tested public benefits of some kind, but they are now in this SSDI category. But many of you have hardworking disabled loved ones who have work records, and so they are receiving SSDI not because they are disabled adult children, but because they have work records of their own. So just understand these two categories kind of work in a different way, but this is what we want to quintessentially understand if we are a trustee of a special needs trust. Section 8 housing, HUD housing, they are traditionally difficult benefits to relate with a special needs trust, but we can talk about that for those of you who might have children that will be in HUD housing. So SSI right now is $943 a month in 2024. In some states, there is a supplement. So remember, this is not a lot of money, but overall, over a period of many years, this can really add up. And for those of you whose children have lost a third, they've lost a third of their SSI because they live with you and you are paying for their in-kind maintenance and support, that's kind of an easy thing to fix. So just know that we don't want to see you lose a third, or your child losing a third of their SSI if we don't have to. All right, so we are heading toward the end of our presentation, and just going to slow down here. So you may remember, as we looked at that circle of a quintessential or best kind of design for a supplemental needs trust, you may have seen a trust advisory committee. So this is just a notice to the trustee, or a reminder to the trustee, that they can hire professionals. Remember that a trustee should hire professionals. They should not be investing the trust money themselves unless they're a professional financial advisor. They should not be doing the trust tax returns. They should hire professionals, What this is saying is, if they are facing a situation with regard to your loved one, something about their mental health, something about their benefits, something that they really need advice on in a committee setting, they can hire or bring on a committee of people to do a Zoom meeting or some kind of a congregative meeting for the benefit of the person with disabilities. The trust protector, let's talk about this again. A trust protector is this person who has authority to remove and replace trustees, review accountings, amend the trust administratively, and basically provide flexibility to the trust. So let's talk about this, because many of you who are either going to do special needs planning or you're going to revisit your old special needs planning, especially if you're revisiting your old special needs planning, please do not beat yourself up if you do not have a trust protector provision in your trust. Now, the trust protector idea takes a little bit of getting used to. If you're not used to this idea that there could be a third person, and we're going to talk about who that should be, this third person could tell the trustee what to do. You must make this modification, or you must agree that we're going to have the trust changed to reflect changes in the laws. This is a tough thing to get in our minds, but what I want you to remember is it's okay not to use a trust protector, but I really strongly recommend that you do, so that you all go into the future with flexibility. Now, a trust protector typically in the world of trust and estates is a person who is independent, a person who is not a family member, a person who has no biases, a person who is arm's length and will do what is needed, okay, without any conflict of interest. But in the world of special needs planning, a trust protector might be a family member. It might be someone who is not independent. So this is something that you're going to wrestle with in your special needs planning. Should my trust protector be a family member versus a professional? Why would a family member be the trust protector? Well, the family member knows what's going on much more than an independent person with your loved one. The family member might be the better advocate for your loved one. So I just want you to start thinking about this. Yes, we do have 1 or 2 people out of every 100 who maybe is a little bit more uncomfortable with the trust protector idea, and it's not required. But I think practically speaking, when we think about the need for flexibility in the future, the trust protector is a very powerful tool. So I want you to start thinking about that issue. Now, we have a new law in 2020. Many of you may be living your lives every day and not heard of this. Many of you have heard of this. And I'm going to venture that many of you that have heard of the Secure Act really have heard about it because you've heard that when you pass away and you leave an IRA to a healthy neurotypical child, let's say, that person has to pay tax on that IRA within 10 years. So if you've heard about this 10-year rule, then you've heard about the Secure Act. So President Trump signed the Secure Act in 2019. It became law in 2020. So the Congress, both sides, Republicans and Democrats, approved it. So it was a bipartisan bill. It is not good for most beneficiaries. It does not affect you as an account holder or a 401k holder or an IRA holder, 403b. It does not affect you. But when you pass away and you leave your assets to children, then it does affect those children. So there are 5 exemptions, and this is what we want to talk about here tonight real quickly. Surviving spouse is exempt. Minor children, defined as children who are less than 21. Disabled persons are exempt, so meaning people with disabilities, people with chronic illnesses, and for people with disabilities and chronic illnesses, their special needs trusts are exempt. And people who are less than 10 years younger than you. So let's say you have a sibling who might be 5 years younger than you or even 5 years older than you. That sibling is exempt from the Secure Act. But let's focus on people with disabilities. So what this really means is that when you leave an IRA to your loved one with disabilities, you leave it to their supplemental needs trust, they get preferred treatment. So I'm just going to check on my next slide here, Jeff. So I'm going to stay on this one for just a minute, and then we're going to wrap up probably in the next 10 minutes. So I want you to envision that your supplemental needs trust for your child or loved one is a circle. I'm going to use my hands here. So this is a bubble, it's a circle. And when you leave them an IRA, you are going to leave them a little circle. So the IRA is the little circle, the trust is the big circle. So the little circle sits right on top of the big circle, and we know that that IRA is owned by the trust. That IRA is owned by the trust. So what this really means is your loved one with disabilities, if you were to pass away and they were, let's say, 48 years old, they would be able to take minimum distributions if they didn't need more money in their trust. The minimum distribution would come out of the little circle into the big circle, and then what? Uncle Sam allows that money to be accumulated inside of the big circle until the trustee needs to use it. What that means is that the rest of the IRA, the rest of the money in that little circle can continue to grow tax deferred. And this is a powerful advantage. And I'm talking about traditional IRAs. Roth IRAs are even more powerful. But what we're saying here is under the Secure Act, a person with disabilities as defined as someone who is disabled in various ways or definitively disabled by Social Security, that person is exempt from the Secure Act. So that's a very powerful thing, considered that other, let's say, healthy beneficiaries are going to have to pay tax in 10 years. So that's what I want you to take away from this slide. That's one of the reasons we were addressing the Secure Act in that big circle with all of those features of a supplemental needs trust. Choosing a trustee, nothing could be more important. Jeff and I have done a webinar many times called Trustee Selection. So if you would like to watch that webinar, Jeff will be happy to send you the link to that Zoom webinar, or actually it's a go-to meeting webinar. And anyway, we look at family trustees versus professional trustees or attorney trustees. We look at whether a trust has court oversight, what are the family relationships, what are the commissions that are allowable to trustees, staying away from conflicts of interest, knowledge and experience, ability versus willingness. So someone could have great ability as a trustee, but are they really willing to serve? And then based on a couple of the questions tonight, remember, we want to build in flexibility so you have peace of mind that no matter what happens with your trustees, you have a trust protector who can always replace trustees or find new trustees. So one of the biggest things that I know many of you are going to worry about is putting everything in place the right way. One of the things I will say about trustees, and another thing I will say about just life in general and how time just keeps going on, and you're worried about, do I have the right elements in place? Here's something that will help you worry less. So you educate yourself like you are tonight. You make the best trustee selections that you can make now based on what you know now. You build in flexibility in case the world changes. And you keep revisiting this throughout your lifetime. Remember that good estate planning and good special needs planning is not just kind of putting it in place and forgetting about it for the next 10 or 15 years, even though life is very, demanding, and many of us do that. Remember that you'll have peace of mind if you revisit this plan every 3 to 5 years, depending on how old you are, and you'll keep revisiting it. You'll be able to keep deciding who your trustees, who your special fiduciaries are throughout the remaining part of your life, and that is the big key. Remember, you'll have peace of mind if you look at it that way. We as human beings tend to think we've got to get it perfect, this is it, and even attorneys do that. But remember, we want to do the best we can today with what we know, and then we can revisit it over the period of years to come. Speaking of trustees, Jeff found these people. I don't know where he found them. He found their pictures, and boy, they are the best trustees in the world. And if you look at these concentric circles, of course, I'm just being facetious there. But you'll notice that big circle at the top. They advocate for the best interest of the person. They understand public benefits and they promote independence and quality of life. But they also understand accountability and they keep accurate records. They keep the beneficiary informed. The beneficiary is entitled to information. They comply with statutory duties under the Maryland Trust Act. But also, they also understand that they should hire professionals to invest appropriately and do the tax returns and so forth. So this is just what I want you to be thinking about as you possibly watch that trustee selection webinar, but also just for your own sake to think about what is the benchmark that I should be looking for in a trustee. So the trustee selection process could be very easy. It could be just, definitely it's my family members, or it could be that you're going to use some kind of an independent trustee versus what we might call an interested trustee. So this is best done when we're reviewing documents. A very nice person on the webinar tonight asked about how to get started. Well, when you get started at our firm, for example, we do a lot of document review. And during that process, you're going to ask questions and you're going to be thinking about who is the best person. And I promise you, if you put in that kind of effort, you will have epiphanies about who the persons should be or whether they should be independent persons and so forth. We're going to talk about conflicts of interest and what are the risks there. We're going to talk about corporations, meaning banks or trust companies versus individuals, advantages and disadvantages. And again, here's the trust protector considerations. And this takes a little bit of open-mindedness and really understanding what is the intention of the law here to allow this kind of thing to happen and getting comfortable with that idea. As you look at your existing estate plan, remember that in a will-based plan, the will is the center of the universe, so to speak. Powers of attorney and advance directives are very important. The person who has this plan, and I'm talking about you now, instead of your loved one with disabilities, you've got to take care of yourself first. Notice that the supplemental needs trust can be right inside the will, or it can stand on its own. Most of the time, the standalone kind is going to be superior for various reasons, but it's not always the case that you have to create a standalone trust. There are ways of doing it right inside of a will. If I were to ask you a question tonight, and many of you have asked me questions, so I'll ask you one. Which one of these documents is the most important document from an attorney's point of view? From an attorney's point of view, which one of these are important, the most important? Well, all of them are important. All of them are. But from an attorney's point of view, the financial power of attorney is the most important of all the documents, because that power of attorney is what you can, where I should say, you can build flexibility, and the flexibility that takes care of you if you are sick, takes care of your spouse, take care of me, take care of my spouse, pay my bills, but here's what will prove it to you. Take care of any person who is dependent on me. So you see, in the event of your incapacity, the power of attorney document is the most important, and arguably in estate planning, it is the most important of all the documents. If you have a revocable trust plan, remember a revocable trust is nothing more than a will substitute. It is a substitute or alternative to a will, and many families with special needs loved ones have revocable trusts with a supplemental needs trust that goes along with it, a third-party trust. Now, here's the supplemental standalone trust, and it could have assets coming to it from a trust, like a revocable trust, or from a will, or from retirement plan assets, or from life insurance, okay? So this is kind of the center of the universe for your loved one with disabilities, and other people can leave assets if there's anyone else in your family that would leave assets to it. So understanding incapacity, how important powers of attorney are to you, not just to your loved one that might have higher functionality, but for you as well. Remember, for you, powers of attorney and advance directives avoid guardianship of your person and property. So this is thinking of yourself first and then thinking about the self-determination for your loved one. So as I wrap up, and I thank you for sitting through this, we're about 10 minutes till the time to end. We are educating you tonight. We are here to educate you We thank the Arc of Frederick and the Arc of the Northern Chesapeake for allowing us to do that. We're encouraging you to create a memorandum of intent or a binder for your loved one, establish your own estate plan, or revisit your own estate plan so that we can kind of build flexibility in there. Establish a special needs trust or supplemental needs trust. We're going to build flexibility in there if you ask me. Think about a collaborative team, your financial needs, whether there should be life insurance. Take this time to really make sure that assets are flowing properly and that we have the right plan in place, and then commit to a series of updates over the years so that you will lessen your worry and know that you're on top of everything. And remember, when the laws change, as they most surely will, we are going to have flexibility to be able to deal with that. Name a supplemental needs trust as the beneficiary of your retirement accounts, because your loved one with disabilities may be exempt if they are meeting certain criteria under the Secure Act. So as I turn it back to Jeff here, I just want to thank you again. What a great audience and wonderful, informative questions. You honor me and Jeff and Elville and Associates with your presence. Set an appointment with us. We are going to collaborate with you, collaborate with all of your advisors, and we want you to know there's an attorney-client relationship. There's nothing to fear, especially if you've never done this before. Bring your current documents if you have done this before so we can review them. We want to help you have a collaborative team. We want you to be informed. We want you to have all the tools and weapons for the future. Bring your questions. We love your questions. But the thing we want to do most is give you the time to think so that you can determine what your goals are. So I thank you, Jeff. I'm going to turn it back to you, and I thank everyone from the Arc of Frederick and the Northern Chesapeake.
Well, thank you very much, Steve. Lots of great information and resources and a great audience, and it's going to get even better because I have several questions for you.
Oh,
so
okay.
We're going to jump into those. That's all right. And lots of good ones here. And so let's do that. I have a couple brief comments at the end, and then we'll end on time. So first question is, sorry if I missed this before, but how do you declare your intent for SDM to the state if there is no official form?
Well, thank you for that question. So it's more of a private thing. Right now, there is no registration of powers of attorney or supported decision-making agreements. So this is a private agreement. It's hard to describe in a very short period of time, but it is a concept that's really very broad, very broad. It is a concept that says that in theory, your loved one has the right of self-determination in a very broad way, and it's a private agreement, and they can sign an agreement or they can appoint someone verbally. And this is very, very hard to get our minds around, but that's why there's no registration, and Maryland does not monitor this.
Okay. Next is, I've heard that if your child/adult is receiving DDA services and you choose to do self-directed, that you cannot do guardianship. Is this true?
I don't think that's true. If I understand the question correctly, I don't think so, because I don't see how any public program could preclude a parent from being the guardian of their child. So I do not think that's the case. There might be some other criteria that the parent is not allowed to do, but I don't think it's guardianship.
Okay, this one's for me about the presentation being provided later. I'm going to mention that at the very end. So we always provide all of our presentations. We have a YouTube channel that has about 300 different presentations on it over the years. So I'll share that with you at the end. What is the average total cost of setting up guardianship and a third-party trust?
That's a great question. So the guardianship is going to be a question of whether it is contested or non-contested. And of course, most guardianships in this kind of planning situation would be non-contested. I'm just going to give you some ranges. I'm going to say that an uncontested guardianship might be $3,500 to $4,000, whereas there's also the cost of a court-appointed attorney. So those fees are going to be capped by the court, or the hourly rates are capped. With a third-party trust, it's going to be depending on your situation and whether we put it inside of a will, embedded, or whether we put it inside of a revocable trust embedded, or whether it's going to stand on its own. And it also depends on your financial situation, because we have flat fees that firms like ours charge, but because we've been very involved in the special needs community for years, we are committed to making sure that people who need these trusts get them. And sometimes we look at financial criteria where someone might not be able to afford our fee. So it's really just going to be dependent on what a range of situations that you may or may not have in your particular case. But that is something that we would discuss in a consultation.
Okay. Next is, if a trust is created in Maryland, is it possible to keep the trust if you move to another state?
That's a great question. So the answer is, in today's modern kind of drafting, yes, the trust could be moved to the new state. So if you have a trust protector, the trust protector could move the situs, which is the location of the trust, from Maryland to another state, and can also move the state law to another state.
Okay, and is a special needs trust the same as a supplemental needs trust?
That's a great question. So you've heard me kind of use this terminology tonight. So that's a very perceptive question. What I would encourage you to think about, to be precise, is that the trust you would create as part of your basic estate planning would be a third-party supplemental needs trust. That is what we would call it, a supplemental needs trust. A special needs trust, in a strict interpretation, is a first-party trust that is approved by the state. But I guess a lot of people use a general term that all of these trusts are special needs trusts, but the special needs trust is typically the first-party trust. A supplemental needs trust is the typical third-party trust.
Okay. And we have two more here. Next is, what is the criteria for certifying disabled or chronically ill as it pertains to the Secure Act?
Well, thank you for that. That's a discussion beyond this webinar, but I will say that the Secure 2.0, which was the second major revision, it did say that SSI and SSDI definitively proves that someone is eligible for as an eligible designated beneficiary. And I'm sorry, I forgot the other part of the question, Jeff.
It is criteria for certifying disabled or chronically ill as it pertains to the Secure Act.
Now, the chronically ill definition is in the code, so that's why it's a little bit more of a discussion. But the chronically ill definition is in the U.S. code, and it does have more esoteric criteria for proof. So that's something we could talk about offline.
And last is, how do you set a life insurance policy to fund a supplemental or special needs trust?
What a wonderful question to end on. So you're going to take your existing life insurance policy and beneficiary designate it straight to the third-party trust, or you're going to buy life insurance within the trust. The trust can actually own the policy and so forth. So you could either have the policy standing on its own and paid to the trust, or the trust itself can own the policy.
Okay. All right. Well, great presentation. I always send out a pretty substantive email that has a lot of the information that Steve alluded to this evening, the morning after our presentation. So video link, presentation slides again, all the presentations that Steve alluded to, and those recordings, our YouTube channel information, information about our friend Kelly Nelson from Maryland Able, and many, many more. So expect that tomorrow morning, and that'll be certainly very helpful to you. As it relates to our webinar series, last thing is we have a lot of different presentations coming up. A couple that might be really good for you to consider is November 20th. We're doing a webinar solely about guardianship. So if you want to take a really deep dive into it, even more so than tonight, Steve is going to be talking about that. And then on December 4th, we're going to have Kelly Nelson from Maryland Able here to talk all about Able accounts and how they provide stability and financial security for loved ones with disabilities. She comes every 6 months or so, and it's always a really popular presentation. So with that said, Corby and Lauren, thank you again for having us, and thanks for all you do as the ARC for the community. And thanks to you, our attendees, for being here tonight. If we can help you in any way, certainly reach out to us, and we'll see you again soon here at Elville and Associates and our webinar series. Take care.
Thank you so much. We appreciate it.
Thank you, Lauren.